You're listening to Biz-Souls, the business podcast with an edge, hosted by me, Rona Lewis, and Jeffrey Hansler. Tune in for perspectives and discoveries about the changing world of business. It's time to connect to the heart, soul, and humor of how business gets done. All right. Welcome to Biz-Souls. I'm Rona Lewis.
I'm Jeffrey Hansler, and we get to the heart and soul of business and the people that make it happen. And our guest today has been making it happen, and he made it happen on Biz-Souls a while ago.
That's right. You were on, what, a year ago? Maybe?
Probably a year, maybe a little bit more.
Yeah. Our guest is Kevin Mayer, an accomplished lawyer and all-around good guy that I've known for a few years. And we wanted to have him back to talk about some of the changes that have gone on and to learn the differences that he has discovered, as well as talk a little bit more about what goes on in the bowels of lawyering. What, am I not good?
You're a little soft, so we'll just adjust.
I work out. I am not. So okay. All right. So welcome, Kevin. Welcome back.
Great to be here.
All right. So talk to us about now. Last time we spoke to you, you had just left like a ginormous law firm, right?
And our career is just launching with Biz-Souls. I mean,
I know. Now that we're all millionaires.
Yeah.
Now
exactly.
We have 7 people.
So, and Kevin was taking the big leap into entrepreneurship.
There you go. So yeah. So.
Absolutely. So I had started my career in San Francisco back in 1985 with a fairly large and an old, well-established litigation and trial firm, which at that time was considered a pretty good sized firm of about 200 plus attorneys. And I spent the first 9.5, 10 years of my career there, and then moved on over the years to a series of progressively larger national and international law firms, finally ending up at a 3,500 attorney behemoth with 56 offices around the world. And unfortunately, when I was there, it was during the beginning and the height of the COVID pandemic. And so in roughly September of 2022, I got a call from a guy named Bill Logan, who was a longtime friend and colleague from our days at University of California. And he had had his own firms for about 20 years or so, and called me up, not thinking that I would have any particular interest in leaving the big law environment after 38 years. But it turned out, as we started talking and looking at the opportunity, that it was a good time to make such a move. And so October 1 of 2022 rolls around, and we open the doors to Logan Mayer LLP. And the rest is history, as they say.
So I've got 2 quick questions.
Go ahead.
Okay. So what was the attraction? I mean, why the leave? I mean, what were you looking for that was missing out of the big law firm?
I'd come to the conclusion that as I became more mature in my legal career, which is a nice way of saying as I got older, that in the big law environment, if you weren't sitting at the very top of the client responsibility roles, that you weren't one of the really huge money makers, you really had no particular ability to influence the way in which your practice was going. And that's particularly true if you're in a satellite office of a major law firm. If you're not at the center of power and gravity, your career may not go quite the way that you expected to or wanted to. And I felt that after 38 years, it was time to look at a different opportunity where I wasn't going to be consistently conflicted out of matters, which was happening quite a bit, where I wasn't going to have to be answerable to others, nor them answerable to me in terms of what we were trying to accomplish and the sorts of cases that we were going to take on and the sort of opportunities that were going to present themselves. And so it became, I think, an opportunity to step into a well-established mechanism that Bill had put together over the many years he had been doing this, and see what we could accomplish. He had always been up in the San Francisco Bay Area. I had been down in Los Angeles since 1997, although I was always back and forth between and San Francisco, in addition to traveling all over the country for our various matters. But we had an opportunity here not only to grow the practice in San Francisco, but actually to develop the practice in Southern California as well. And so I found that an attractive opportunity.
And your specialty, if I remember, was OSHA work, correct? That was one of the
Well,
areas.
OSHA is certainly one of the areas that I've been in. The vast majority of my career has been in the litigation and trial of product liability, toxic tort, environmental, OSHA, construction, real estate, and really now more commercial litigation and trials as well.
What's toxic tort?
Toxic tort involves claims where an individual or group of individuals will claim that they developed some sort of injury or disease, could be any form of cancer, systemic disease, that is diseases of the various organs of the body, or other types of acute or chronic illnesses as a result of exposure to chemicals or substances,
Gotcha.
whether in a consumer grade or industrial grade product or something that they might encounter in the workplace. So it could be hydrocarbon solvents, it could be asbestos, it could be welding fumes, it could be silica, it could be chlorinateds,
Gotcha.
or any combination of those things.
Interesting.
So is that kind of like, what was John Travolta, Civil Action or something?
He had a
Exactly. The Civil Action was one of the better known movies.
movie.
I don't remember that one, but that's okay. I'm not.
As was Aaron Brockovich.
Oh, okay,
Yes,
right.
yes,
Aaron
yes, yes,
Brockovich,
yes.
even better. Okay. Well, thank you for explaining that, because my mind, because of food, toxic tort, a really bad pie. That's my mind.
And it could be.
That's right. That's right.
so,
It's in that vein.
A follow-up question to that. So do you have the resources, or are you missing the resources from a big firm to handle those cases? Or, it's pretty much, if you're knowledgeable in it, and with, I don't know, if automation comes in or AI comes in, if it's helped you, or is it a lot harder now without a big firm and all the resources?
It's an excellent question. And I can tell you that over the course of my career, when I was doing a lot of work with the Fortune 100, so you're representing some of the largest oil and chemical companies in the world, typically they are looking for breadth and depth in their legal team. And indeed, I was working as part of large teams, large groups within those law firms doing this sort of work. When you're on your own and doing that sort of thing, it isn't as though you've lost all the knowledge, all the experience, all the trial chops that you've gained over the course of time, but you don't have the same amount of resources available to you anymore. The well-established legal assistants and the associates and the of counsel that work under you in developing these sorts of cases. So while those opportunities are not quite as frequent as they used to be, they still are there. And indeed, I work as national counsel for a particular company that I advise on their legacy toxic tort litigation and supervise the work of local counsel. I consult with other companies on their work as well, even if I'm not the day-to-day litigation counsel handling a particular case.
Okay. Well, that's so you have do this people. Here, I need this, do this.
Yeah, and really now there's sometimes not anybody else you can turn to but yourself.
Right. So I have to do this. Right. Yeah. Yeah. Well, and that's an unfortunate part of entrepreneurship, when you have to wear a lot of hats.
Well, and one of the things that I've heard, and I have no idea, I mean, you're right in the thick of it, AI, one of the groups that is going to be greatly affected by AI are paralegals. Because now AI, especially if you've got the law database there, you ask AI for the case, for the backup cases, the law that it applies to, and all that. And so is that the case? Are paralegals, can you get along with AI and not, have
as long as it's not, Scarlett Johansson. So
Right.
or sounds like
the answer, I think, is no. Right now, you can't rely on it. AI, as far as I can tell, is going to be a tool, and a very important tool, that we as attorneys and our legal assistants can use to help us develop and understand the evidence in a particular case. It is not going to replace people unless those are people who do not get on board with how to use the tool well and properly. So what do I mean by that? The cases that we're involved in, indeed any case, involves the sometimes mind-numbing exercise of having to go through the documentary evidence. Whether you're looking at decades worth of scientific data and medical studies, scores of email communications, things of that nature, because that's where the evidence is. And that's what you will use when you are actually questioning witnesses about what the documents said, what the documents meant, things of that nature. AI is going to give us the ability to go through those things at an initial cut level, organize things well for us so that we know where to look and what we're looking for. But at the end of the day, there's no substitute for human eyeballs and thought and analysis of the documents, particularly if you're a trial attorney. Well, AI isn't going to do your job for you.
All I hear is that, you have to kind of check the work because it makes mistakes. It's not. It
does,
not
and that's particularly true in the area of legal research. I could give you examples when ChatGPT first came out, and everybody was telling me how wonderful it was and how fantastic it was. I tested it several times. I would say, draft me a short brief with citations to authority on the following issues, blah, blah, blah. And it would give me a brief that was relatively short. It made sense, but the citations were all wrong. Either they were citing to cases which existed, but didn't stand for the proposition that they were being cited for, or they just simply made it up. I mean, literally made it up. And of course, you knew that because you would go to pull the case from your LexisNexis or Westlaw or what have you, and you couldn't find it, or you would find that the citation was simply inaccurate. And indeed, some attorneys got busted for this. There's a famous story of an attorney in New York who submitted a brief to the court that had AI citations that were wrong, and he got caught.
Wow. And what happens? Technically, what happens? So is it rejected? Does the court say you're a bad boy? Does the court say just resubmit this?
Well, no, there was a significant wrist slapping that went on, and I don't know if the attorney was sanctioned, but we as attorneys have a duty of candor and honesty with the court. We are obligated, among other things, to make sure that the authority that we are citing to the court as precedent is accurate. And we also have a duty to make sure the court is aware of any potential contrary authority that may call into question the position that we're advocating. Because the court has no interest in A, being misled, or B, and more importantly, reaching the wrong decision. Well, the only way it can make an informed and correct decision is to have accurate citation to authority.
That makes sense. So basically, he got caught cheating.
Basically.
Yeah.
So with the judges, now technically a judge should have the background on that stuff. So did the judge catch it? Or does the judge have staff that did a double check on his stuff and catch it?
That's a good question. How do they find out?
All we ever see is court cases on TV, and the judge is like, no, that's not the case. Or anyway.
It's a really good question, and a lot of it depends on the judge and the court. Some courts are extraordinarily well funded. They may have research attorneys. The judges may have clerks on staff that do a lot of the digging, read the briefs, provide a bench memo to the judge as to what the issues are, what they think the questions are that the court should ask the parties in order to arrive at a determination. Some judges like to do their own research. Some judges do not. But here's what you have to understand. Judges are extraordinarily busy. They are overburdened with a lot of stuff. And we as the attorneys have to take into account who our audience is. An overburdened judge who doesn't have time necessarily to dig into everything. So we have to make it easy for them. We have to give them something that's concise, that expresses the positions properly and efficiently, and doesn't play games with the authorities.
All right. Well, go ahead.
You've got a question on that.
Yeah, I do. Well, I wanted to move over to talk a little bit more about being an expert witness. And I know that some lawyers are kind of like, oh, I would love to do that. And they're like, our friend Thane is on TV and radio all the time. How did that happen? How do you do that?
Well, it's an interesting question. As you probably are aware, I have had the privilege of writing and speaking about expert witness practice in civil litigation and trials over the course of 30 years. And in fact, just last year, I gave 2 addresses to 2 different audiences. One was an audience to the Litigation Council of America, which is the Trial Lawyers Honor Society. And the other was to a convention of expert witnesses from literally every possible discipline and industry you can imagine down in Florida. And this was a course really on how to be an expert, how to depose an expert, how to testify at trial, and how to challenge the admissibility of expert opinion testimony at trial. And these are things that attorneys have to know, but the experts have to know them as well, because a lot of people who are true experts in the field don't understand that what they do in the day-to-day practice of their profession is not the same thing as what goes on when they're under oath in the deposition seat or in the witness chair at trial.
Gotcha.
Sorry. I turned her. I turned around.
Don't turn your back to the camera ever. I try to give him media training and he doesn't listen.
Kevin.
He has like one book on law.
I've got 2 books. I've got here. Hang on. Let me see if I can pull this over.
Because he wants to bond with you.
So the book is Tools of Argument: How the Best Lawyers think,
of course,
argue, and
being
win.
able to read is a useful trait as well.
Think, argue, and win. And I've got another book somewhere else about being an expert witness, because I'm a dive instructor, scuba diving instructor as well. And,
on the off chance that someone gets eaten by a shark, he wanted to be ready
No,
for it.
when the dive boat burned up.
What dive boat?
The 31 people were killed. It was up in Northern California.
Okay.
And
yes.
The watchman, I guess, fell asleep. And anyway, it was really bad. Except that boat was the same boat that I had go out on. It's the exact same model of a boat, because they
So
use the
you
same
were
model.
expecting them to call you.
So I thought, hey, if they're going to
On
get
the
it out.
chance.
So I was reading up on it. It's difficult. They tell you all the different. You should write a book, Kevin. Then I can put it on my library.
As I say, I've written quite a bit on these subject areas, and mostly
Just put it all together, put a binder around it, someone's going to buy it. That's all.
They get published in legal publications for other lawyers to read.
There you go.
Well, I don't get legal publications, so really, put it in a binder and make a book out of it. That'd be great.
Exactly. There you go.
That'd be great.
We have to start off from this proposition, Jeff, and you'll get a kick out of this. There's the lay interpretation of what an expert is, and then there's the legal definition, right? So the lay interpretation is that an expert is someone who has made all the mistakes that can be made in a very narrow field. And then the legal definition is someone who, because of their experience, education, training, gives them the ability to allegedly objectively assess the facts and circumstances in a particular area in order to arrive at an opinion based on reasonable probability in their discipline on the specific subject on which they want to testify.
Marissa Tomei in My Cousin Vinny.
Right.
That was somebody who, because of her experience, not necessarily because she was formally educated in it, not because she was even formally trained in it, but because somebody who understood automotive repair could testify on that subject with the imprimatur as an expert.
Right.
So real quick, and I won't be offended at all about this. So scuba instructor, instructed a lot of students, certified a lot of students, been on the similar boat. And then we switch over to my corporate stuff, which is decision-making. I do how corporations make decisions, how to think, critical thinking, strategic thinking, all those things. Would you want me as a expert witness?
Like he's bucking for a job on the air.
No. I'm not bucking for a job. I'm trying to ask because this is his expertise.
Well, so let's talk about your diving situation first. First of all, I assume that you are PADI and NAUI certified. And so the issue becomes, what do I want you to testify about? Is this a case that involves issues in which a NAUI certified diver could potentially offer one or more opinions to the jury on a disputed fact issue that they are called upon to decide?
Well, I'm an instructor, not just a diver. That's
okay.
Multiple levels up. So same question.
But again, the same analysis applies. What would I call upon you to testify that would make the expression of any opinions that you have come to in a case helpful to the jury to help them resolve a disputed fact issue, which is being submitted to them for decision in the case?
Okay.
So if there's an argument with a wetsuit, you're in.
Okay. Could be.
Yes, I'm actually being serious.
No, here's the thing. The boat caught on fire. The divers were all down. There was the main entrance, and then there was a small hatch to get out. And the divers, most of them died, unfortunately,
horrifying.
not died, fortunately by smoke inhalation versus burning alive.
Oh,
Because they couldn't get out.
They couldn't get out. So,
what kind of dive boat is that's very dangerous.
No, it's whoa, don't say that. So I'm 6'4", so I'm like one of the max sizes, pretty big guy. Operating those boats is pretty thin. It's really not an expertise though. It becomes more of an opinion. I couldn't say this is the size hole it should be. This is the standard size on boats. I could look that up.
Right. So the issue becomes, what is being alleged in the case? Is it that the dive masters who are on the boat, their conduct fell beneath the standard of care for somebody in their position under the circumstances? That might be something you could opine on. However, if this was simply a case of the hatch was locked and it shouldn't have been locked, do we need an expert opinion on that for the jury?
Got it.
Probably not, because that speaks for itself. That any lay person can understand that. While you could opine on it, the jury doesn't need it.
Right.
It's not going to advance the ball for them necessarily.
Gotcha.
All right. So moving back to you, how do you go about finding an expert witness for the issue you would need one? Is there a list somewhere or?
Right. Well, there could be. I mean, it depends on the type of case and the subject area. So a lot of my experience in trial has been in the trial of these toxic tort cases. So typically I'm dealing with physicians and scientists. And usually I want to go find the leading experts, if not in this country, in the world, who have researched, written about, treated the specific disease that is at issue in those cases. I want the epidemiologists who have studied the incidence of disease in human populations for this particular exposure and this particular disease endpoint. I want toxicologists, that is the science of poisons, those who have studied the adverse effects of chemicals and substances on humans or other living organisms, who may offer opinions about the toxicology of the particular substance that we're dealing with in the case. If I'm in a case involving construction and we're talking about engineering issues, I may need to go find a structural engineer or a civil engineer who can offer opinions about whether certain engineering principles were observed, certain standards were observed properly, the engineering calculations in building construction were followed appropriately, etc. If I'm talking about a defamation case in the equestrian industry, I may need an equestrian expert who understands how reputational issues can result in harm to the owners or operators of horse stables, things of that nature. How do I find them? So some of it is just based on years of experience working with people. Others are going to other attorneys who may know people that I'm of the type I'm looking for. There are a number of organizations out there that I could go to and ask, hey, who do you think are the real experts in this area? There are certain expert witness organizations that exist, TASA, Exponent, other entities like that have whole stables of people in-house that do, among other things, litigation consulting and expert witness work at trials. And depending on the type of case, I may go to them and say, hey, who do you have here? Then, of course, I have to do my due diligence and sit down and meet with them and make sure they're the right people.
Yeah. And that's like Speaker's Bureau for expert witnesses.
Yeah. Yeah, really. And a short answer on this one, because I know Rona has another subject question for you. So how do you train them?
I do.
Do you? Didn't you want to talk about trial? How do they pick juries and stuff like
yes.
that? Okay.
I forgot.
So how do you have to coach these guys? I mean, do some of them take a lot of work? How do you know that they're going to be a good expert witness and not be just bore the jury or bore the...
A lot of it is instinctual. There are some people that you know as soon as you sit down and spend a couple of hours with them that they're going to be excellent experts. They're going to have the ability to get on the stand and actually teach the jury and teach them effectively about what could be very complicated issues. And yet they have the ability certainly to teach students in their own institutions about these things, and they can teach the jury as well. And they just have a certain aura about them that makes them very effective. There are others who could be literally the world's expert in a particular area, but they would be absolutely horrible in a courtroom because they don't know how to communicate to people at the level that they require in the trial environment. And so even though they might be God's gift to this particular discipline, you don't want them testifying because they simply wouldn't be effective. They may be better served as a consulting expert. That is someone who you're going to use to help you work the case up, but not necessarily the person whose testimony you will present to the jury on these issues.
So does anyone ever, I learned a lot about the law from TV, so I know it's all true. So
I wish it was that exciting.
I know, right? I always, not always, a lot of times I will hear, the other side say, well, you're getting paid for this, aren't you? Does that still happen? Because, they're expert witnesses. They get paid. It's kind of common knowledge, don't they?
Certainly, it's one of the things that we bring up in our direct examination of an expert, because you want to talk about the fact that they're not there doing this gratis, although I can tell you a couple of stories about that would interest you.
Okay.
But there are some experts who are just brutal in their billing practices. These are people that have no business charging the amount of money that they are charging for their testimony. It's just outrageous.
Do they get it?
And sometimes a jury can be influenced by that, because if you do your job effectively in cross-examination, you can demonstrate that this person is really not worth what they are charging. And indeed, they are nothing more than a hired gun.
Can I ask what the range is?
Sure. Some experts charge $200 an hour, and I'm now familiar with experts that charge $1,500 and more per hour.
Wow.
Greedy bastards. Sorry. Was that out loud? Sorry.
All depends on the discipline, and a lot of it is market forces.
Yeah.
What are they able to get away with?
That's true.
Rona's heading to a defamation suit from expert witnesses.
What are you, crazy? Nothing like that. All right. So let's move on to talk about jury selection. It's not a business thing, and yet there are a lot of people in business who want to get out of jury duty.
Well, it's really interesting. Obviously, one of the foundational underpinnings of our country is the right to trial by jury. Mm-hmm. We really do have an extraordinary legal system in this country when it is not being abused.
Yeah.
When it is being handled right, it is a truly extraordinary mechanism for resolving disputes between parties. And it's been this way since before the Declaration of Independence in 1776. So it's really a hallmark of our society that we allow 8 people in federal court, 12 people in state court to sit in judgment, both civilly and criminally, on disputes and resolve these to the best of their ability. And people take that obligation very seriously. Do people want to sit on juries? Do they want to be stuck in a courtroom sometimes for weeks? No, they don't. But once they're there, they do take it seriously, right, by and large. There's exceptions, of course, there always are. But I think once people get into the room and start deliberating and understand the gravity of the responsibility that's been placed on them, they're going to try and do their job correctly.
Yeah,
that's good to hear, because I know it's got to be tough when they're selecting the jury, because people don't want to be doing it. They don't want to be there, and to see that shift or know that shift, how do you figure out the ones that are going to care?
Well, the process takes care of a lot of that. So what do I mean by that? All the cases in which I've gone to trial over many, many, many years have been what we call long cause cases. These aren't just 1 or 2 day jury trials. They're often a week, 2 weeks, 3 weeks, 4 weeks, sometimes more. And people can't all sit there and do that. Not everybody is eligible to serve on such a jury. It could be because they're the sole financial support for their family, and if they're not working, the family doesn't have any money. They can't survive, or their employer does not pay for jury service. Or if they do, they only pay for a very brief period of time. So there's a financial hardship component. There can be social components, a new mother who cannot be away from her child. All right. The answer is, oh yeah, bring the kid and have him sit there and you nurse the child during trial. No, that's not the answer. So they're probably not going to be eligible. Full-time students are typically not available to serve on juries because if they're sitting there, they're not in school and they're not going to get their degree or what have you. So there's some self-selection that goes on at the beginning where people are hard-shipped off the jury. They're able to convince the court and the parties that they really shouldn't be there. Then during the preliminary phases, let's say we're using a jury questionnaire to try to identify the biases, the prejudices, the interests, et cetera, that an individual may have in the case, the parties can engage in some horse trading. So from my perspective, the pro-defense jurors may identify themselves, the pro-plaintiff jurors may identify themselves. Both sides are well aware of it, and they can agree among themselves that those jurors should be eliminated for cause right at the outset because they should be. They just should be. There's no way they should sit on that jury, and both sides know it. Then the tough cases are the ones that you identify in voir dire, the actual oral questioning of the jurors, where you try to elicit information from them that will help you either exercise a challenge for cause, that is, that their biases are such that they cannot sit fairly and objectively on this case, and you've satisfied the court that that is correct, or to help you exercise what we call a peremptory challenge. That is a challenge for which you don't have to give a reason. And each side has a certain number of peremptories that they are able to exercise when the jury is being. So that is, you can, after you exercise your challenges for cause, then you start striking jurors based on peremptories. And of course, there's a lot of thought that has to go into that because the juror you may be getting rid of could be followed by somebody who's much worse. And you have to know that coming in. So there's strategy that goes along with this as well. And that's why in big cases these days, the parties will typically engage jury consultants who are usually PhD psychologists to help them in the process of evaluating the juror questionnaires, actually sitting there and evaluating the jurors as they are answering the court's and the parties' questions during voir dire. So you can get some insight into who these people are and what makes them tick.
They're being judged. They're being judged before the judge.
Well, they're being judged and we're being judged.
Right.
Lady, from the moment you walk into the courtroom as an attorney, you are part of the show as well.
Of course.
And jurors will come to know you as well as your spouse does during the course of a trial.
Yeah, I've actually gotten called for jury duty a couple of times, and I was let off once because I work for myself, and the other one because I think I was a little too New York. I was like, just because you put the guy, and of course I had my accent, in an ill-fitting suit doesn't mean that it, and then they're like, all right, you can go.
Your Honor, the jury thanks and excuses juror number.
That's right.
Yeah, exactly. So just a quick question for now, because I definitely got to have you back again. Are there really groups that their specialty is they're in the background? What was that movie with Gene Hackman where they're picking the jurors? There's a whole support team and with the lawyer with an earphone, and they're saying, yeah, that juror's no good.
Well, isn't that
that part I have not seen before. I haven't seen that sort of electronic communication in the courtroom. But as I say, the parties have their jury consultants, and they're usually sitting there with us at counsel table during the jury selection process. We actually introduce them to the venire. We don't tell them who they are, but anybody that's probably been on one or more jury trials before has a pretty good idea of what's going on. Okay. And they're sit there working with us, taking notes, analyzing the jurors' responses. And then as we huddle up to decide who are we going to strike, who are we going to try to keep, who's the other side going to strike, and so forth, this is where all the horse trading goes on.
There you go.
Good.
So did you want to bring up the Trump trial?
No.
Too much?
No, absolutely not. What I want to know is, A, are you happier right now in a small firm?
Oh, that's a good question.
Are you happier in a small firm?
Yeah, there's pros and cons to anything. I think on balance, this has been a really great experience. I don't have, of course, the secretary and the legal assistant down the hall and the associates and so forth that I could call on back in the good old days and have them do X, Y, and Z for me. I'm certainly not traveling as much as I used to. It used to be that I was on a plane literally every week sometimes to some part of the country to deal with clients and witnesses and cases and what have you. So that's changed a little bit. But the good news is I have a lot more control over my schedule now. I have a lot more control over the sorts of cases and clients that I work with and the fees that I charge. and the things that I can do and not do or shouldn't do in any particular matter. So from that perspective, it's been very refreshing and energizing.
Well, it's nice when your wife and kids actually recognize you.
Okay.
Yes, exactly.
Two more. I got two more questions.
Okay, go ahead.
I got two more. The first one is, so obviously the dress code has changed, and I mean that all in jest.
Here we go. Yeah.
You took today off, didn't you? The dress code isn't that casual. Or you're
Friday,
working at home.
It's Friday of Memorial Day
I'm working
weekend.
in my home office today,
Yeah.
and I didn't, and here we are. So I will put a coat and tie on when I have to go to meetings. For example,
Right.
I had a meeting yesterday out of the office. Boom,
Yeah.
I put my suit on, and that was
Right.
that. But
So-
most of the time, if I don't have to go anywhere and I don't have to be on a client Zoom call or a court call, this is the de rigueur attire.
And there you go.
So-
And for our listeners and viewers, he asked us if he should put on a
Right,
tie,
right,
and
right.
we said
No,
no.
we said no.
We said
Exactly.
no.
So the relaxing dress code is not applying in court for everybody. It's still suit and tie.
Absolutely. That's absolutely correct. And in some courts, there is greater formality than in other courts, amazingly enough. I would never, ever, ever go into a courtroom not wearing a suit and tie. I wouldn't even wear a blazer and slacks. It's
Right.
suit and tie. We are expected to be professional. We are expected to act like professionals. We're expected to look like professionals. It's what people expect of us. And we have, I think, a duty to both the court and to the process to represent ourselves accordingly.
At least you don't have to wear a white powdered wig and robes like they do in England.
Yeah, exactly.
Yes, exactly.
Although that'd be easier because some of them wear jumpsuits under the robes.
Some don't wear anything.
So here's my last question, and then we're running out of time.
Yeah, we gotta go.
We gotta go. Just real quick. So my partner's son he's going into his last year of law school, and he wants nothing more to be in front of juries. He wants to be a trial lawyer. Any quick tips for anybody in law school that's heading down that road?
Absolutely. So he really has two options to help him out. One is he goes into the public sector initially. So he either goes into a district attorney's office, a city attorney's office, the United States attorney's office, or the public defender's office. He will get courtroom experience virtually off the bat, and we'll get a lot of it. I mean, he'll be in court every day in all likelihood in those sorts of circumstances. The other way is to go into a small active litigation and trial firm where they actually do try cases. Going into the big law environment, it's just not going to happen for them, if at all, until many, many, many years later. Trials today in that environment are few and far between. Those that are taken are typically taken by very senior attorneys who don't have a tenth of the trial experience that their equivalents did several decades ago. In the old days, the guys that I came up under and the women that I came up under, they were in court all the time. You know, they'd go from trial to trial, 2-3 day events, and they'd go have lunch with the client and come back with 3 new files and drop it on the associate's desk. And those cases might end up going to trial. And part of the reason for that today is it's economics. It's extraordinarily expensive. There's a lot more at risk now than there used to be. I mean, when we talk about runaway juries, we've all heard the stories about certain verdicts that are completely out of control. Think about it this way. When did you first start hearing our government talk about dollars in the trillions? That was really only 2 years ago.
Right.
Before that, I never heard anybody talk about trillions. And now they just throw it around like it doesn't matter. Well, if that's true, then it's not so outrageous for juries to think about things in big numbers as well.
Millions.
We're starting to see verdicts that have crossed into the billions.
Yes, we have.
And that's pretty scary. So if you're going to go to trial, there better be a really good reason for it. And there are good reasons for cases to go to trial, and the financial piece as well.
There you go. All right. I got nothing after this. How about
Kevin, this is great.
you? Yeah,
I love
thank you.
this.
Thank
I love
you
this.
for coming on and chatting about it. And it was really hard to get you to come on. I know Kevin and I had a drink and just catching up because we've known each other for a while. And I'm like, come on the podcast. Okay, when? No, really. No, really.
I always enjoy talking with you all. You ask great questions. It's a lot of fun to talk about things that I'm passionate about. And I'm really appreciative of the opportunity.
Yeah, and this is, we only know a certain amount about lawyers, and people say bad things. I have a lot of lawyers in my family, which is the prerequisite if you're Jewish. You got to have a certain amount. I don't know what the exact percentage is. So it's it's good to know what goes on behind it, just so we understand it more. So Kevin, thank you again for coming on. I'm sure we will have you on again for other things we don't know.
Absolutely.
And for all you out there, thank you for watching and listening, and please subscribe. We could use the numbers. I'm Rona Lewis.
I'm Jeffrey Hansler.
And this has been Biz-Souls. We'll see you next time.
Thank you.
You've been listening to the Biz-Souls podcast with your hosts, Rona Lewis and Jeffrey Hansler. Did you have fun? Subscribe, rate, and leave a review. It's very much appreciated. Talk to you next week.